And just a reminder, we are recording again. And that's for some of our participants who weren't able to join us. So welcome back. This is the second session of our California Arbitration Mentorship Program. This is session 2 out of 6 sessions. And we have a wonderful topic today, and we have a wonderful mentor that I want to introduce just very briefly. You all have the bio sketches. We've sent that across earlier. But today we have with us Donald Smiley, who is going to be talking about the mechanisms for appointment of the arbitral tribunal. And I did kind of mention last week at the end of our last session at the end that Donald has some very interesting experience in the entertainment industry that I'm sure all of you will enjoy hearing about. And I've told him that we're ready to hear all kinds of war stories too, as much as he can tell. I'll chime in now and again. I'll also be fielding questions and watching for hands that are being raised and any questions that come into the chat so that we're interactive as we were last session. And then we'll reserve some time with about 25 minutes left in the hour for just some general Q&A, just if you have other burning questions about, becoming an arbitrator, any other questions about this field, use us as your resource today. We're here with you to answer those kind of questions as well. So without further ado, I'm going to go ahead and turn it over to Donald, and we'll get started.
All right. Well, thank you for having me. Thank you to CalArb. And I suppose I need to have the one sentence disclaimer that all the views presented are my own and not CalArb's, so that we have that covered. Mechanisms for appointment of the arbitral tribunal. Okay. Generally speaking, you start thinking about what you're looking for in a tribunal about the time that you're drafting your arbitration clause, if not even before. As indicated, I work primarily in the entertainment field, although I cover a lot of ground. When I have a client shows up and says, well, I have a deal that needs to be put on paper, I look at what it is that might happen between the parties, because that's why you have a contract to begin with. And in the entertainment field, I'd say a large portion of the disputes that arise end up having to do with licensing and monetary values between parties. And so if I'm drafting something and I think that that's going to be the primary problem in the future, whether it's royalties for IP or minimum guarantees under a contract or some sort of scheduling issue, I want to make sure I've covered what I need in an arbitration clause. And that also comes down to, and that's been covered, where you're going to have your arbitration, and if there are any special provisions you need for discovery or other things that need to go into that clause. Because all of that leads to how you get your tribunal. Generally speaking, and I'm not going to be real specific because there's so many jurisdictions around the world, and depending upon which institution you use, they're going to have their own rules. Normally speaking, arbitrations are one of two ways. Either it's ad hoc, where the parties just agree that they're going to have an arbitration and you pick people out of the air that you can agree to, or a system that you can agree to pick, and you have your arbitration. Most arbitrations, though, go through institutions. And so whether with the ICDR, whether you're in Singapore, Dubai, wherever you're at, the institution you go to will have its own set of rules. A lot of times, if you're having a 3-person tribunal, they will let each side select an arbitrator, and those 2 arbitrators then may select the neutral, who's the chair. Most of these locations have sort of fallback clauses where if you haven't picked somebody in a certain period of time, or if you can't agree on something, then the institution may appoint someone. Or the institution may turn around and send you a list and say, narrow it down from this list and someone will be appointed. That's really kind of the steps that you take to get an arbitrator. You're allowed, if you're picking the arbitrator for your side, in many cases, you're allowed to have a limited ex parte communication with that arbitrator, largely to find out their availability. They have to remain impartial, and so you really can't go into any specifics of the case, but you can at least find out, are they, are they available, and are they somebody that you would like to use? The steps end up for this, after the arbitrators are selected. Well, I'll back up. I'm sorry, I'm getting ahead of myself. As you're going through trying to figure out, and this is the presumption that you're picking an arbitrator for your side, you then have considerations that you would like to give. Whether or not it's someone that you know, whether it's opinions that they've written in other cases that seem like they might be sympathetic to you, whether you have talked with your colleagues and chatted with them to find out, gee, have you used this person? Do you know them at all? What do you think? And so you're looking for an arbitrator that will understand your case. And generally speaking, most institutions will say, well, we have experts in your particular area, whatever it is. And so most people will turn around and say, let me hire an expert in a field, any field. Most of my cases, again, are in the entertainment field. And so for me, getting into entertainment, I started with the Independent Film and Television Alliance. It's called IFTA. And IFTA represents the largest portion of independent film and television sales agents. The people that go to the Cannes Film Festival and actually license content for both film and television. And I only was accepted onto that panel because I had been an advocate for a number of years for various sales agents that were involved in arbitrations under the IFTA rules. And so I received recommendation letters from other IFTA arbitrators and was placed on their panel. I'd say about 4 years ago now. Well, I take it back. It's been 3 years since IFTA became part of the ICDR, which is the American Arbitration Association, for administrative purposes. IFTA still has its own set of rules, just like other subjects may have specific rules, but IFTA has model contracts. They expect most of their sales agents to sign contracts that incorporate the IFTA regulations and rules so that everything is uniform. And that means the entire industry is attempting to work off of one set of standards, which for arbitration purposes makes it simpler. A large portion of the IFTA arbitrations are sole practitioners. Occasionally we get panels. Generally speaking, it's the film studios themselves that are not IFTA members. And there you're more likely to have a panel if you have a studio involved than if it's independent. One of the nice things about IFTA was that they have called the seat for arbitration Los Angeles for everybody, just because that's where the industry is based for the most part. At the time that the ICDR took over IFTA, I believe we had, if I had counted correctly, we have about 45 arbitrators that covered the entire world. So there weren't very many of us. And we were all essentially experts in film distribution primarily, but certainly the IFTA rules and regulations. And that's how I got started. Generally speaking, depending upon your jurisdiction where you are, there's going to be a seat, or I mean, an institution somewhere near you that probably gets the largest portion of the work. Those are the rules that you should learn because those are the ones that probably statistically you're going to end up being in front of most of the time. Now, when it comes back to how you're getting to your arbitrator, and I don't mean to digress, but I indicated that you get to have at least some chat with them generally as to availability. But you're also looking for subject matter. Do they understand it? In some cases for international arbitration, there are rules about diversity for arbitrators that perhaps they can't be of the same nationality as the parties, or you have other issues like that, and that's generally put into the institution's rules. And again, that's what you picked when you've drafted your agreement. And so all of that is thought of long before you ever get to an arbitration.
Donald,
yeah.
let me stop you there for 1 second
Sure.
and just maybe we can get a read from our cohort, our group. How many of you have been in the position either of appointing an arbitrator or helping your, a partner in the law firm you're with appoint the arbitrator, or that you've had you've drafted the clause that becomes the kind of the blueprint for how and what kind of credentials your arbitrator might need to have. So maybe we can get that sense from our group. Anybody want to share? Anyone on mute that wants to share but hasn't? Well,
I guess I will add, there is no wrong way necessarily to do any of this. And everybody probably does it a little bit differently. There are different things that are more important to somebody than it is to somebody else. Maybe expertise is the most important. Maybe you want a judge or a retired judge because you want somebody with a broader sense of experience. Maybe you want somebody who has shown that they can problem solve and write very clear and defined awards, but yet they don't know anything about your subject. But everything else sort of fits. And so you're happy to explain your case to them, but you know that they have the mental capacity to understand it and write a clear award that you're hoping for. So again, there's no one way to do it. And it's sort of up to you, your partners, or what you think is important.
Yeah, I think that's really an excellent point. And, just to give a little bit more about the importance, I guess, it's really stressing the importance of the arbitration clause. And a lot of times we hear about arbitration provisions are kind of written into a contract at the 11th hour, and written by transactional lawyers that don't have as much experience with that. And there can often be, then some issues that come up once a case is ripe for arbitration. So it is important to really, be as proactive as you can, and see that, a number of institutions have their model clauses. So there's a lot of guidance on that. We'll go ahead and take the question from Aisha, if you want to go ahead and speak your question.
Yeah, thank you, Gara. Thank you, Donald, for coming in today and taking us through such an important aspect of the entertainment industry. My question was with respect to the difference between an arbitrator and expert determination in the clause. So like in the entertainment industry, there's a bidding process through which the live streaming platforms, they pick up content. And if we have a clause where we are talking about expert determination on a particular aspect of the bidding process, which we do not intend to be arbitration, we are not talking about dispute or dispute resolution, but we are saying that if there is a difference in interpretation on, say, a certain aspect of the bidding process, so and so would be an expert to determine this aspect of the difference in interpretation. So are there real life instances like that where something has been determined to be an expert determination and not an arbitration of the certain aspect, because it's a highly technical process, and probably a layman is not better suited to respond on it, and an expert would know better on that particular point?
Well, I have drafted agreements where, well, as an example, I've drafted agreements between partners in production companies where there might be an even number of partners. And that lends itself to how do we resolve a dispute between the partners, which is a lot like how do we resolve an interpretation of a bidding process. You have sort of each side saying something and there's no way to resolve it in and of itself. In those cases, I have drafted clauses that say it's referred out to an expert. And it's either an expert that both parties can agree to when the drafting process is being undertaken. So they both agree that the president of the studio will decide, or whomever it is. I've even had them try to say that I would decide because I'm the drafting attorney. I try not to do that conflict-wise, but they can either select an individual or simply define who it is that they want to refer it to. It becomes more like a mediation at that point, where the expert is going to listen to both sides and try to see if he can work out a solution. Generally, when I do those type of clauses, it's an interim step, and that if things are not resolved through the expert, then it goes to perhaps an expedited hearing process for an arbitration. IFTA, because it has to do many times with film distribution, and you want the content to get out there and not be tied up for years. They have an expedited process, and you have, a limited number of days to render a decision, so that commerce can continue and entertainment can move on. Very few people want to see a film if they know it was made 3 years ago or 4 years ago. It's stale and they want to see the new stuff. And so you have steps. In the United States, real estate sales contracts, if you go through a realtor, they typically have a clause that says you have to have mediation first before you can go to arbitration. And if you don't attempt to mediate or go through a settlement process first, you can basically throw the party out of arbitration if they filed immediately. And so those things are enforceable. Again, arbitration is a process between two parties, and the arbitrator is not there to impose their rules necessarily if the parties have set forth the rules that they would like to follow. And so if you've included the use of an expert first, then the arbitration tribunal or ad hoc or however it's being done will follow those instructions. Because that's really what the clause is. It's instructions of how do we proceed if there is a dispute that we can't resolve.
Mhm. Yeah, thank you so much for that, Donald. Aisha, do you have a follow-up question, or did that cover it?
It's covered. Thank you. It was absolutely clear. Thank you, Donald.
Okay.
Thank you. And I think that that's an interesting point to be made, that arbitration and mediation, right, are different tools within the alternative dispute resolution toolkit. And I think what we're seeing a lot more in the in current arbitrations is step clauses for sure, but also mechanisms within the arbitration itself where parties may shift tracks. So we hear a lot more talk about facilitating settlement during an arbitration, for example, or the parties attempting to mediate while the arbitration is either stayed. They've talked to the arbitrator. In some cases, their parties are going to the arbitrator to even ask that the arbitrator step in as a mediator, because perhaps they've already gone through so many steps of disclosure of discovery or other procedural steps in the case, or the exchange of information, where so much time and energy has been invested into really bringing this arbitrator up to speed on this particular case, and the parties seek that out. So just to keep that in mind. So thanks a lot for that question. Donald, is there anything you want to say towards that? Have you ever had to shift roles in between midway?
No, I have only as an advocate, where I've been representing one party, but step in to essentially try to mediate between both parties. I've not done it as an arbitrator. AAA, to the best of my recollection, frowns upon it and wants you to have a separate mediator just for conflict purposes. I do know that there are some institutions where they let you switch back and forth. What the ICDR, I believe, and I know AAA, they allow you to simultaneously go through mediation and arbitration. So you don't have to stop the arbitration to have mediation sessions. You can do it sort of in between your hearing dates, or, just before, or even just after. But you can do it simultaneously. And so, as an arbitrator, I always encourage people to talk. I think it's more effective and satisfying if the parties reach an agreement that they can agree, that they agree upon and can live with, as opposed to having me come up with a decision that they may or may not like. And so sort of self-determination is the mediation route. And if that can work, great. And if it can't, then, as an arbitrator, we're there to settle the disputes and say, okay, based upon what we've been given and what the law is, or what the contract says, this is how, as an impartial neutral, we call it. And, as you're selecting the arbitrator, one of the most important things is, if I use a US sports analogy, can they call balls and strikes? Are they able to make decisions, and sometimes make very difficult or tough decisions? Decisions that sometimes, gee, I really feel for that party, but they haven't proven their case. If you're in front of a jury, maybe the jury rules in their favor on a sympathy vote. But as an arbitrator, we're not really allowed to do that. We are there to judge the facts and the law and then render a decision based on that. So it's sort of knowing your case ahead of time, not only what it is that you need. Do you need third-party discovery? Well, maybe you need to have that in your clause. Or maybe when you're picking the seat or the institution or the law that you're going to arbitrate under, you want to have one that will allow you to write in third-party discovery, because most places, they won't allow that. But if it's in your contract, then you at least have an argument that I should be able to do that. If it's an accounting case, maybe you need the records from the accountant. But if you know that ahead of time, then maybe you can add something like that into your clause, that all accounting records be turned over. Generally everybody will enforce what's in the clause. And so you look at that ahead of time.
Excellent. Donald, one thing that kind of came to mind when you were talking about kind of the number of arbitrators that are, really specialized. I think you mentioned there were about 45 arbitrators that, super familiar with the IFTA rules, and may get appointed by the institution or parties over and over. What can you tell us a little bit about this process of appointment when you've been in front of the same lawyers or the same parties? So we've got all these, great rules, the IBA conflicts of interest rules, which if all of you have had a chance to look at that, if you haven't already, that's a really important, starting point. Then we've got, the rules for the seat, and we're talking about California. If California is the seat and these rules, California is one of, I think, the most strict disclosure principles and protocols out there. Maybe you can talk about some examples of how that works.
Sure. And I guess, IFTA won't get too mad at me if I turn around and say it's actually a little incestuous. Because there are so few of us that qualify as arbitrators, most of us, maybe a third of that 45 are full-time arbitrators. The rest are practitioners who are also arbitrators, and I was one of those. It doesn't always happen, but it's not unusual to find an IFTA arbitrator as the advocate. And because we know the ins and outs of those contracts. And so we're sought out because we can provide the expertise in being an advocate. And so it's not unusual to have your disclosures where, yes, I've been opposite this arbitrator in X number of cases, and I've arbitrated in front of this arbitrator when they were an advocate. Generally speaking, because it's a relatively small community, even though it's worldwide, everybody signs off, and I've not heard of an objection or a disqualification because of that. I would think that, say you're doing nuclear science, there are probably very few experts in the field. They're not going to be advocates necessarily, but your arbitration panel, if you're looking for experts, is probably going to be relatively small. And so if you have a number of disputes, you may well turn around and have the same arbitrator pop up at different times on different lists. So again, it kind of depends on the area you're working in, but certainly in the entertainment field, everybody knows everybody. And it's sort of like trying to be an actor or an actress. Everybody likes to get into the field, but those that are in, there are very few, and we generally all know each other, if just by reputation. But more likely, we've all faced each other at one time or another. And so even for non-IFTA matters, I may get called because they know my litigation background. And they know that, I handle certain types of cases. As a litigator, I did a lot for the personal management industry. The people that sort of, manage the actors or, tell them how to dress, what roles to take, and basically act as the business extension of the actor. And I've spent a large part of litigation in probably the last 10 years representing managers. And so if it becomes a dispute between an artist and a manager over their contract, then I'm somebody that gets looked at, and they know that most of the time I've represented managers. And so I become sort of on that side of the equation. And if there's going to be a tribunal, then I may be a pick for the manager side, where there are certain attorneys and advocates in Los Angeles that only will represent the actor. And so they may end up on the other side. And then the quest is to find a totally neutral chairperson. And it doesn't mean that I can't turn around and say, you know what, even though I may lean a little bit more to a manager, the manager was wrong. It depends on the case. But it just gets back to it's a small world. And any of the players, there are only a limited number of people that license the contract or the content worldwide. Whether it's, television in Germany, because the TV buyers there license for television and for theatrical release. It doesn't go the way it does in the United States, where they're separate. If you get someplace like, Cambodia or Laos, there may only be one or two people that license. content there. And so you, after a period of time, you get to know who they are. And if you've done either as an arbitrator or an advocate, you've done licensing deals with these people, then, you know, everybody knows everybody.
Mhm. Yeah. Yeah, I think that's so helpful and to really ground it within, you know, your industry. And I think it's really food for thought for all of you, and to think about the diverse industries that you're in. Maybe a lot of there's a lot of parallels in terms of, you know, the world becoming smaller and people knowing one another by reputation. Although there's a very, you know, there may be a large pool of arbitrators generally, as you're maybe searching for arbitrators that are best suited towards your particular industry and dispute, you know, knowing that they've got an industry specific background could be a very big factor as to why you would want to seek the appointment of that arbitrator. And I appreciate, you know, Donald's also talked us through some of these other mechanisms that happen. So that in the sense of, just because you have identified the arbitrator, it doesn't mean that they're going to be the one appointed. In particular, institutions oftentimes are asked to make what they call an administrative appointment of the arbitrator, but then the parties have typically 15 days. If it's an expedited case, it may be a little bit less, to you know, to actually disqualify the arbitrator, and it could be on any grounds. So there are, you know, it's not just a done deal, and I'm glad that you know, Donald was able to highlight some of that for us. Yeah, we've had a chance to talk about, you know, party appointments versus having a sole arbitrator and having a panel versus an institution appointing the arbitrator. We've talked about ad hoc. We've talked about conflicts of interest and disclosures. And again, I think most importantly, and as you know, Donald really spoke about the arbitration agreement itself and the usefulness of thinking through that early on and proactively, to, you know, to have that guidepost for the ultimate process of how a dispute will be addressed. So I think at this point, I want to go ahead and open it up to everyone if they have any other questions or comments, and if you want to ask anything outside even of entertainment, or outside of the specific topic, but within the realm of entertainment, this is your chance. So I'll open it up to all of you to ask questions.
And let me add one other thing here.
Yes.
If you don't have what you think you need in the arbitration clause,
Mhm.
assuming you can get the other side to agree, you can always change the clause even after you've started the arbitration. The problem is, at that point, you're adversarial, and the chances of getting somebody to agree to much of anything is slim, but it can happen. And certainly if you have experienced advocates on either side, they may want some of the same things that you do that were not included in the agreement.
Mm-hmm.
So while you're hoping that the agreement covers everything, so that if you're tooth and nail with somebody, that you don't have to ask them to change anything, there's at least a possibility that you can do that later in the process, assuming you can get them to agree.
Yeah, no, thank you for really highlighting that, and maybe it's you know, it's a good reminder that, you know, it is the parties process, and parties can make it as flexible as they would like as well, and just kind of a reminder that there are a number of tools that can help the process to be even more efficient, and not all of those ideas have to come from the arbitrators. They can come from counsel as well, and rightly should.
Right.
So I see a couple of hands up. Since Aisha had the other question, I'll let Yaki go first, and then I'll turn to Aisha. Yaki, the floor is yours.
Thank you so much, Gerda and Donald. I really appreciate the opportunity to ask a question. Actually, when I listened to Donald's explanation of arbitration in the entertainment industry, I'm very curious about how to appoint a neutral chairperson. I noticed that Donald mentioned that some attorneys may tend to represent actors, some may tend to represent the manager side. And when these attorneys translate their careers into the arbitrator, how would they manage to keep neutral if they have spent lots of time representing a specific side in their previous career? And I'm very interested in learning how attorneys can become neutral if they tend to represent a specific side.
Sure. I think generally what you do when you're trying to get a chairperson in that type of situation is look for somebody who doesn't represent either managers or talent to be your chairperson. So maybe they work or used to work for a studio. And so they're not necessarily one side or the other. And that's the simplest way to do it. Otherwise, you go to a certain extent by reputation and past experience. As the person that you would like to appoint as the chairperson, have they demonstrated that they can be fair to both sides? And do you have past opinions perhaps from where they've gone both ways? I have represented talent in arbitrations with IFTA. I've also represented production companies. I've represented distributors. And so I've covered basically all of the grounds and have represented everybody at one time or another. And so I know that there are other attorneys out there that have a wider range than just doing one thing. Now, there certainly are attorneys that will only represent actors. There are a lot of those in town because there are a lot of actors with a lot of money. And so the attorneys want to make sure they represent the person with the most money. But there are plenty of others, especially, I have my own practice. I don't work for a large firm. A lot of times law firms themselves get reputations for the type of clients that they have, whether they're, employer versus employee, or, they represent studios versus representing actors. When you get those reputations for a larger firm, then you're not necessarily going to find an advocate there or an arbitrator there that is necessarily neutral. And so you look for a firm that's probably more well-rounded, or one that at least the arbitrator has demonstrated that they can consider both sides.
Yeah, thank you for that, Donald, because again, just thinking of other industries and, parallels, you could say the same kind of thing, maybe in the insurance industry where, there's certain attorneys that really only represent the insurer and some that only represent the insured. So these are some of the kind of nuanced pieces that counsel are going to be thinking about and looking at as they make these decisions, of course, as wing arbitrators or party-appointed arbitrators who are tasked with appointing the chair, we'll be thinking about and keeping in mind. Institutions are looking at those type of things as well. Sometimes it's the institution that is called in to make that decision. And where, at the end of the day, if no one can agree on this, it may go to court. It may go to the supervising court to actually appoint your tribunal.
Generally, most of the institutions have time deadlines for appointments.
Yeah.
And if you miss the time deadline, then whether it's the court or it's the institution, they will step in, and they typically have at least one, if not two other levels of how things get done. I know I'm on panel with the ICDR, and they turn around, and if you haven't picked somebody, they send you a list and say strike a certain number and rank the rest, and they may select from the highest rank. And if for some reason that hasn't worked, they may just appoint somebody. And they may take that list and just pick a name from that list and say, all right, you guys haven't decided, so here's the appointment. But it's like a three-level approach. And I believe most institutions have something like that in place. So it will get done, and generally the institutions have thought it through. What if this doesn't happen? What do we do next? And they've worked it out to give you a chance to do it. And if you don't, then they will step in and do it.
Thank you for that.
It's much like as an arbitrator, if I leave decisions to the parties and they can't make a decision, or I give them 2 weeks to let me know something, and they ignore it, then I may turn around and unilaterally make a decision and say, okay, you had your chance and this is where we are.
Thank you.
It's their arbitration.
That really illustrates exactly the different mechanisms. It's not just going to go unchecked. There are other procedures in place, and the show must go on in some respects. Well, let's turn to Aisha. I see your hand is up if you would like to ask your question.
Hi, yeah. Donald, so my question was with respect to the scope of arbitration in entertainment contracts. Now, it could pertain to, say, contractual rights. For example, in case of celebrity management, it could be about what was the scope of the service that the celebrity manager was giving. So that's much simpler because you're just talking about a contractual right. But it could also be about determination of a statutory right, especially in entertainment contracts, where you could be talking about, is there a copyright in this? Who owns the copyright? When did the copyright begin, and things like that. So when it is about determination of statutory rights, is arbitration a sought after dispute resolution mechanism? Or if at all, then how does enforcement work in these cases? Or does it mean that if it is determination of statutory right, it necessarily has to go through a court route and not through arbitration?
Okay. Well, pretty much anything can go to arbitration. If you have it in, again, we go back to the clause. If you've hired a personal manager, or if you've hired your accountant or your lawyer or anyone else, you've got an agreement in place generally. There's been a problem in personal management where a lot of times they've done it just off of a handshake. And that leads to different sets of problems. But if you have an agreement in place, you can always put in an arbitration clause. If your dispute is over intellectual property rights and who owns it, well, typically you're looking at who's filed for copyright registration and what is the name on the registration. In disputing copyright itself, typically in the United States, you end up in federal court. But if you have an arbitration clause, it doesn't mean that you can't go to arbitration. Because once an arbiter has made a determination, you end up having to go to court to get that entered as a judgment. And so it still ends up in court eventually. One of the larger issues that we face in entertainment, regardless of whether it's for rights or for anything else, is the sense of privacy. Entertainers do not want their dirty laundry out. Just as a quick example, I had a world famous actress who, for one of her films, the rest of the cast was putting out a scrapbook. And they included, behind the scenes pictures and things for a film that had come out decades earlier. And we received a cease and desist letter saying she didn't want to be included and she wasn't giving permission, even though she's smiling and waving at the camera and doing everything while this was going on. And so I advised the client, we don't want to fight this, but write her back and tell her that instead of hiring the lawyer, you've hired a publicist. And the publicist is going to print her cease and desist letter worldwide so that everybody knows how petty she's being. And that was the last anybody heard from her. And the book in that case got published. And I say that as an example, largely because everybody wants to keep their own personal sense and who they are in actuality different from whom they are as a screen persona. And so they pick arbitration a lot because they don't want their laundry to be aired. Unless you're Johnny Depp and you want to go through everything. I will add, I was actually contacted by his team at one point and interviewed for an hour as to whether or not I wanted to go represent him in that case. And I said no. Not that I have anything against him or his case, but as a sole practitioner, for me to do that case would mean I'd have to give up the rest of my practice. And I didn't want to do that. But, it all turned out well for him, except that he aired literally everything. And you will find that most people in the entertainment industry, their reputation is more important than almost any contract. I could say that I've made my whole living off of people's egos because it's, well, don't you know who I am? I can get away with doing this regardless of what the contract says. And so they would like to arbitrate things because they don't want people to know what's really going on. I had one that went away just before we really got into it. It was going to be an arbitration. It was a personal manager that I represented, and the actor's attorney was someone that I knew well. And he called and said, listen, the actor is going to say that your manager ruined his career and that he was a horrible manager and he's going to try and put him out of business. So you'd better walk away. And I said, well, I don't have the specifics. I did, but I wasn't going to go through it there. But why don't you ask your client about the 2 sexual harassment complaints and something about a hooker in Vegas and the fact that he has a morals clause in his contract, and that the manager kept all of that out of the public eye so that he could continue to receive millions of dollars from his contract. And within a week, I had a very large sum of money that was due to the manager because reputation was more important than anything else. And so knowing that, a lot of, arbitration becomes important because people want to keep working together, but yet they want to have things sort of off to the side and get resolved. A couple of years ago, it was Scarlett Johansson suing Disney over release dates that they released the Marvel film straight to video or streaming, and she didn't have a chance to collect box office bonuses that were written in her contract. Well, that's just because COVID changed distribution. There have been a lot of, we went through a whole phase of arbitrations that were COVID related, whether it was negotiating or interpretation of what force majeure meant or how it applied. I had one arbitration where one country financed a film with a US based production company that was going to be filmed in another country. And the financing was dependent upon a certain actress having a particular role in the movie. COVID hit halfway through filming. They had to shut down. I believe they were in Italy, and they shut down, as did the country. And she hadn't filmed her scenes yet. And so 2 years go by and the financier goes, well, I want all my money back because there was a contingency that wasn't met. And with some prodding, actually, I gave them some prodding. They ended up working out a deal before the arbitration where they were able, enough time had passed, they were able to resume filming, and they promised they would start filming her right away so that the financier was happy and it could move forward. But it was just one of those COVID type issues. I recently finished one last month where films were licensed to a particular country with a minimum guarantee, where they are promising to pay several $1,000,000 for, I think it was 2 films in this country with certain deadlines for payment terms. COVID hit. There was no film distribution because the cinemas were shut down. So this particular licensee did not have the funds to turn around and make the payments. So that went to arbitration. And I've seen several of those where it was just the side effect of having no economy, and there was really no way to have anything in a theater. And so there was no income coming in to turn around and make any payments. You go to arbitration, you have it resolved, and I would say more times than not, as a licensor of product, you probably go back to the same people and license the next film to them because you keep working together because there really aren't that many places to go. So that's a nice way to say, let the arbitrator make the decision so we don't have to, and we can actually keep a working relationship.
Yeah. Oh, those I think were fantastic examples, and those are the ones that Donald could tell us some details about. We can only imagine what details he's not able to tell us, and what's under lock and key with ironclad NDAs and the like. So such an interesting industry, and I think we were so fortunate to have your perspective. And I'm sure I can attest, and I've seen some of the comments. Thank you, Simon, for the comment. Really appreciating the anecdotal stories. This is what we aim to do with this program, and to get you all in front of very seasoned arbitrators of a lot of experience, and to give you that nuance of how arbitration fits within specific industries. So all that's left to do right now, we're at time, is to thank Donald for being with us today, and to thank all of you. If you'd like to clap or put up your hand to show and express your thanks, appreciate that. And we'll go ahead and adjourn for today, and we'll see you back here in a couple of weeks' time. We have again another very interesting topic, and a couple of law firm perspective you'll get from a large law firm perspective at our next session. So appreciate everyone's attendance. Thank you again, Donald. We really enjoyed you being with us today.
My pleasure, and I hope some of this helped. There's a lot of ground that could be covered, and trying to fit it all in, it went somewhat quickly. So I hope people have been able to take something from this, but thank you all.
Appreciate it.